Okay, so off of the south coast of South America, there is a chain of islands called the Falkland Islands. Now, after my first video about Scarborough Shoal, a commenter asked me about the Falkland Islands. I am not one to back away from a challenge. You issue me a challenge in the comments, I will respond. So here is my response. So, the United Kingdom has maintained a continuous presence on the Falkland Islands for about 200 years. Argentina has also maintained an inconsistent claim on those islands since 1820, a very short-lived post on those islands in the late 1820s, early 1830s, and then has inconsistently maintained its claim ever since. So let's go ahead and take a look at the history and take a look at the international law as it relates to the Falkland Islands. So Argentina itself declared its independence in 1816. When it was founded, it was known as the United Provinces of Rio de la Plata. Yeah? And it was essentially focused on what is now northern Argentina, around the Rio de la Plata, the river that Buenos Aires, the capital of the country, is on. It was through the mid 19th century that the country, like the United States, expanded westward and Russia expanded eastward. Argentina expanded southward, down towards the island at the tip of South America known as Tierra del Fuego. So, in 1767, the Spaniards had a colony on the Falkland Islands. Now, was there somebody already there? Yeah, the French. The French had a short-lived colony at Port Saint Louis, which the Spaniards took over in 1767 after the Seven Years' War and renamed it Puerto Soledad. Okay? So they took an existing French colony and replaced it with their own and turned it into a penal colony. In 1771, the British and Spaniards came to an agreement that they would each have their own posts on the islands. So the joint occupancy of the islands between Spain and Britain actually date back about 250 years to 1771. Both nation states claimed sovereignty over those islands. Spain claimed it as being a part of their viceroyalty of Rio de la Plata, which is what became Argentina. But the Spaniards abandoned that settlement in 1811 during the height of the Napoleonic Wars. They never reestablished their presence on the islands. Spain and Britain had contesting claims. They were on the islands simultaneously, both respecting each other's settlements, not interfering with them, but also maintaining their own respective claims on the entire archipelago. Spain abandoned its settlement in 1811. Argentina declared independence in 1816 and voiced its claim to the islands in 1820 and tried to set up a settlement with Louis Vernet in 1829, a settlement that failed. And by 1833, the Argentines had been expelled from the islands, and they've basically been expelled from the islands since, with that brief exception in 1982. Over the course of the 19th century, the United Kingdom solidified its control over the islands. More settlers went to the islands, and Britain established effective control. However, Argentina, for its part, at least up until 1850, did maintain an active claim on those islands. And that's actually very important under international law. So long as Argentina continues to protest and continues to maintain its claim, they can actually make a legal stand based on that claim. So, in 1850, there was a ratified treaty between Argentina and the United Kingdom. And yes, I do put a very high priority on ratified treaties because territorial transfers and territorial provisions are best handled in international law by ratified treaties. So, the Convention of Settlement actually does not directly address the Falkland Islands. But after this treaty, Argentina actually dropped its claim over the islands for 38 years until 1888. It wasn't until 1888. And that 38-year hiatus is going to become very, very important. Now, the islands themselves are not mentioned in the treaty, but when there is a treaty, there is a doctrine, okay, known as uti possidetis. Okay, basically that means if you control it, it's yours. Okay, and so the legal doctrine of uti possidetis is the prevailing argument here. Okay? So when a state, and there are multiple cases, which I'll get to in a few minutes, in international legal tribunals in the ICJ, in which this principle comes up. That once you no longer voice the claim anymore, you lose the right to that claim. The principle is called estoppel. Okay, so the principle estoppel then prohibits you from reestablishing that claim. So there are at least four, relevant cases. One is the Island of Palmas arbitration in 1928. This was an arbitration between the United States and the Netherlands, okay, over islands known as Palmas. And what happened was the Netherlands had maintained continuous and peaceful display of state control. That was the key that was used by the arbitrator. Continuous and peaceful display of state control. That is what the Netherlands established on the island. The United States did not contest that. The United States claim was dormant. And so, according to the arbitration, the Dutch display of sovereignty over those islands was more convincing than the United States' dormant claims, and thus the arbitrator awarded the islands to the Netherlands. In 1962, there was the Temple of Prayer Vihar. This is a case between Cambodia and Thailand. So the ICJ, the International Court of Justice, ruled in this case that there was a map that was made by the French of their Indochina colony, and it was put inside this temple. The Thai knew about this map. The Thai never contested this map. And because the Thai never contested this map, the Thai effectively acquiesced to this map. And so the Thai then lost any right that they had to challenge the boundary of Cambodia with Thailand. This boundary was set by the French when Cambodia, Laos, and Vietnam were all part of the French Indochina colony. 1992, Nauru versus Australia. Okay, so the ICJ ruled in its preliminary hearings that delay on the part of a claimant state may render an application inadmissible. Basically, what the court is saying there is if a claimant state delays or does not make a claim, then any claim that they might have afterward does not have any standing. One final case, the Pedro Branco case here in Southeast Asia, 2008, between Malaysia and Singapore. Now, one has to understand, of course, the interlocking history between Malaysia and Singapore. When Malaya, the Malayan Federation, which became Malaysia, was founded, Singapore was a part of the state at founding and was administered as a part of the British colony on Malaya. But the Tunku Abdul Rahman and his racist policies, and it was literally a racist move, literally kicked Singapore out of Malaysia. Now, some would argue that in the long run, this was actually pretty good for Singapore. Though Lee Kuan Yew lamented at the time and later said that Singapore is probably the only state in history that has become independent against its will. Which at that time, Singapore actually did not seek independence. It was literally forced to independence by Malaysia. Now let's get back to the Pedro Branco case. So there's an island in between Singapore and Johor, the southernmost state in West Malaysia. And Singapore exercised acts of sovereignty, okay, by establishing a lighthouse and other administrative organs on that island. And so when Malaysia failed to respond to these acts, those are the words of the ICJ. When Malaysia, quote, failed to respond to these acts, unquote, Malaysia lost any sovereign claim that it had to those islands. So the ICJ and the previous arbitration clearly established the international legal principle that if you do not maintain your claim, you lose it. Now, you can continue your claim, you can continue your protest and not have effective control, and at least you can claim that your claim is valid. Even if the international law behind your claim doesn't work, at least you maintain that claim so that maybe later that you can establish your legal rights. Well, did Argentina do that? So one thing that we can see from Britain clearly established at least a dual claimant with Spain in the 1700s. Argentina, legitimately, Argentina claims to be the successor of anything that was under the governance of Rio de la Plata. And that's actually consistent with a case that I mentioned in a previous video that goes back to the Burkina Faso Mali case. Okay, the principle of uti possidetis juris. Okay? So on that point, Argentina is on very solid ground. Where Argentina kind of loses it a little bit is not the fact that it failed to establish its own outpost in the late 20s, early 30s, 1800s, 1820s, 1830s. It was that after the 1850 treaty with the UK, Argentina dropped its claim for 38 years. That's where Argentina runs into some problems with maintaining its claim. Because if you look at the decisions that were made by international judicial organs in the 20th century, the principle of estoppel, and also the principle of uti possidetis relating to the Convention of Settlement in 1850, renders Argentina's claim sadly weak. What happened? 1982, Argentina invaded the Falkland Islands. I was 11 years old when this happened. Oh, I was not quite 11 years old when this happened. It's one of the first major disputes, probably after the Iran revolution and the Iran hostage crisis, that I actually have a very strong memory of. And so when Argentina invaded the Falklands, there was almost universal agreement that it was a clear violation of the United Nations Charter. And this is actually remarkable in 1982. The UN Security Council condemned the invasion. Now, in 1982, to get the Security Council to agree on anything would have been like moving the moon. Okay? Because you had, of course, the Soviet Union on one side, which would criticize anything done by anything pro-British or pro-American, and then of course you had the Americans and British on the other side. The Soviet Union did not veto this, and the People's Republic of China did not veto this. Yeah? So it was actually rather remarkable that the UN Security Charter condemned the invasion. It was a clear violation of Article 2, Section 4 of the UN Charter, which prohibits the use of armed force to advance a territorial claim. Yeah. So Argentina was clearly in the wrong. The United Kingdom, for its part, has the right under international law, confirmed by Article 51 of the UN Charter, though, of course, the right clearly predates the UN Charter, in going down to the Falklands and uh, rejecting or ejecting the Argentinians from the islands that they invaded. Now, after this failed military adventure by the Argentinian junta, the junta collapsed. Now, the Falklanders have repeatedly reestablished and reiterated their desire to remain British. They are British subjects. They do not want to be Argentinian. In the last half of the 20th century, on 5 occasions, at least 5 occasions, the United Kingdom has proposed bringing this to the International Court of Justice. From 1947 to 1951, just after the ICJ was formed, the United Kingdom proposed both Argentina and Chile to go to the ICJ to settle outstanding territorial disputes. Argentina refused. 1955, the UK unilaterally submitted a case to the ICJ, but Argentina refused jurisdiction. Argentina did not have an optional note on file with the ICJ accepting universal jurisdiction and did not specifically agree to jurisdiction on this case. Once again, in 1969, the United Kingdom offered to settle the situation with Argentina at the ICJ, and the Argentinians refused. Argentina, if you believe your case is so strong, why don't you accept ICJ adjudication? ICJ has the best international lawyers at its disposal. They will look at the international law and they will look at the history in a fair manner to make sure that the proper decision is made. But you're afraid to go there. Why is Argentina afraid to go there? Now, some have tried to compare the Falklands to, say, Scarborough Shoal and say, well, proximity is the guiding factor in international territorial claims. That is actually not the case. That is not true at all. Proximity has absolutely no bearing when you have an island that is inhabited and you have a state that has a sovereign claim, like the United Kingdom does, or like the United States does with Hawaii and Guam. Yeah, especially Guam, because Guam was ceded to the U.S. by a treaty. Now, Scarborough Shoal, which I mentioned in the earlier video, is not an inhabited island, but the Spaniards showed clear jurisdiction over that island as early as the 1730s. Okay, and the Chinese didn't have anything for 200 years after that. So there is no comparison there. Proximity is not the end all and be all of international law. Sovereignty and international law and treaties are the end all and be all of international law.